The federal law which prohibits nonviolent felons from possessing firearms has once again been ruled unconstitutional after the Supreme Court's recent 8-1 decision and GVR of this case. And now the Trump administration has changed the landscape for the restoration of rights with a new rule, and we're going to see if they plan to double down with that type of win in front of the Supreme Court. Now, before we jump into the video, I want to thank one of the main supporters of this channel, which is 1st Phorm. 1st Phorm's an amazing company. They have great supplements. I use their protein powder and a lot of their supplements every single day, trying to get healthier. But one of the cool things about them, they're pro-freedom, pro-America, and they support what we do here on the channel. So if you're interested, check out 1st Phorm using the link down below. And if you order something $50 or more, you will get a free 4-pack of energy drinks. As I mentioned in the intro, in this video, we're going to be talking about a critical Second Amendment case involving nonviolent felons and their ability to own firearms. The Trump administration has now issued a proposed rule, and they are changing this rule, which would allow for the gun rights restoration of prohibited individuals for the first time since 1992. Now, this coupled with the Range versus Garland case, which is pending in front of the Supreme Court, this can completely change the landscape on this Second Amendment issue. This Range case, which is in front of the Supreme Court, involves a challenge to the federal laws, which prohibit someone with a nonviolent felony or misdemeanor, in that type of equivalent, from being able to own, possess, or acquire firearms. The Trump administration recently asked for the Supreme Court in this case to give them a 30-day extension of time to file their Supreme Court cert. In essence, Pam Bondi and the DOJ have indicated that there is potentially a shift in how they want to treat this case and this issue, and they want some additional time. And so the court there gave them 30 days, but that time is about to lapse. With a new rule that was issued by the Trump administration, we kind of got a glimpse about maybe how they want to handle this issue. But now the Trump administration's deadline to file their petition and these papers to the Supreme Court is set to end next Tuesday, and we will get an answer, how maybe they intend to extend that to a protection even beyond just that rule, but potentially challenge the federal law at large nationwide in front of the Supreme Court. Now, for those not aware, the Range case involves this issue of an individual losing his 2A rights under federal laws. 26 years ago, the individual here, Mr. Brian Range, was convicted of concealing some of his income so that he could obtain additional food stamps for his family. And because of that, he was charged with a felony, and a result of that is he's lost his 2A rights essentially forever. Now, as a result of that, Mr. Range brought a lawsuit in a federal district court in Pennsylvania, and he wanted the federal government's law to be struck down as applied to him individually. On review, the district court sided with the federal government, but then this was elevated to a 3-judge panel in the Third Circuit. And the Third Circuit issued an opinion citing history and tradition in finding that individuals constitutionally entitled to bear arms are only law-abiding responsible citizens. In essence, they ruled that Mr. Range is not one of the people afforded protections under the Second Amendment. This case, after the 3-judge panel in the Third Circuit, was then elevated to the en banc panel for the first time. And on review, the panel there, the en banc panel, held that 922G1 as applied to Mr. Range is unconstitutional. The Biden administration at that time then sought Supreme Court reversal of the decision, but after the Supreme Court issued an 8-1 decision in the Rahimi case, which dealt with domestic violence restraining orders and the access to firearms for those types of individuals, they then remanded this Range case back down to the Third Circuit with a grant, vacate, and remand for a new decision in light of Rahimi. And on re-review, the Third Circuit en banc panel once again ruled the same way, finding that Mr. Range is one of the people afforded 2A protections. In the decision, the en banc panel stated that we agree with Range that despite his false statement convictions, he remains among the people protected by the Second Amendment. And because the government did not carry its burden of showing that the principles underlying our nation's history and tradition of firearms regulations supporting disarming range, we reverse and remand. They stated that at the root, the government's claim that felons are not among the people protected by the Second Amendment devolves authority to legislators to decide whom to exclude from the people. We reject this approach because such extreme deference gives legislators unreviewable power to manipulate the Second Amendment by choosing a label. And that deference would contravene Heller's reasoning that the enshrinement of constitutional rights necessarily takes certain policy choices off the table. Now, that decision by the Third Circuit en banc panel was issued in December, and then at that time, the Biden administration decided to appeal this up to the Supreme Court. They wanted Supreme Court review. But as we all know, Trump won the presidency, and there's been administration turnover, and a lot of things have changed, and so now this is in the hands of the Trump administration. The federal government, through Pam Bondi and her office, recently asked the Supreme Court for a 30-day extension of time so that they could reconsider whether actually they want to seek Supreme Court review on this issue. The Supreme Court recently granted that request, but that extension of time is set to end next Tuesday, and the DOJ will need to file their brief or some sort of additional statements about what they want to do on this issue. However, soon after getting the extension of time, from the Supreme Court, the DOJ's office here issued an interim rule essentially removing Attorney General's delegation of authority to the ATF for the processing of applications when it comes to the restoration of rights at a federal level. Through the interim rule, the DOJ will begin to allow individuals who are not dangerous to public safety to use this statute and petition to have their gun rights restored. And since 1992, Congress has prohibited the ATF from using funds to process gun rights restoration applications, which has been a big deal. It essentially made the statute obsolete and useless, but now a lot of that has changed with the interim rule. Now they're finally going to have an avenue to restore rights at a federal level. Now, under the interim rule, the ATF will no longer handle relief applications. The DOJ will instead carry out the statute and process petitions for gun right restorations. Now, this is a huge leap forward, and it's going to remove the barrier that was prior in place for the federal restoration of rights. Now, one of the interesting things with this is that we have a complete shift on how the DOJ will treat nonviolent felons in these types of gun possessions. Well, that is in the essence kind of what's also going on with this range case in front of the Supreme Court. The DOJ has received a temporary extension in this case to decide what they want to do, but one of the options would be to let the Third Circuit en banc panel decision sit as precedent when it comes to the range case and not seek Supreme Court review. The other option would be to have the new DOJ petition and essentially take a position that the federal law at large is in fact unconstitutional. Now, there's also the issue of mootness, which could come into play also here in front of the Supreme Court, where some of the justices could take the position that with the new restoration option that was opened up by the Trump administration, Mr. Range now has a new avenue to restore his gun rights, and maybe that his challenge here is no longer valid because he could get access to firearms under the new application. Of course, I would love to see the Supreme Court strike down the federal law at large as unconstitutional, but with the deadline soon approaching for next Tuesday, April 22nd, for the DOJ and the AG's office to respond to this issue, there could be a larger game plan when it comes to nonviolent felony issues and possession issues, where maybe you have the Trump administration actually take a position that this federal law is unconstitutional, kind of adding a 1-2 punch beyond just the rule that they put in place, but maybe even agreeing with the challenge against the federal law. We will now wait to see what the Trump administration and what their strategy likely is going to be going forward in this range case, and also maybe what the new interim rule, what impact that will actually have on this lawsuit. But I would love to see this administration double up beyond just the new rule and the new application for the restoration of rights, but maybe also bring in support of this challenge in front of the Supreme Court, a pro-2A stance saying that the federal law in the DOJ's eyes, in the Trump administration's eyes, is in fact a violation of the Second Amendment. So that's where this currently stands. This is a very significant case for a lot of people, maybe who are barred forever from being able to possess firearms. And this could lead to a broader nationwide change when it comes to 2A policy. So as we get more information, as Tuesday passes and we get additional information from the AG's office with their petition, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm and a signal to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.